Barry Coates.
Tēnā koe, Mr. Speaker. I would also like to echo condolences and support to those affected by the earthquake. It's at such times that communities come together and we see the amazing resilience and strength at a community level that really makes this country special. So our thoughts are with those who are having to put their lives back together again after the earthquake. Mr. Speaker, I would like to make comments on this bill, the Trans-Tasman Patent Attorney and Other Matters Amendment Bill. And I echo many of the previous speakers who have been highly critical of what the passage of this bill has represented. The genesis of this bill came from a high-level political announcement between the Prime Minister and then Prime Minister Kevin Rudd in August 2009. Unfortunately, political announcements, and particularly those driven by a particular ideological position, do not make necessarily for good legislation. And I think what we've found in this case, that there has been a major political problem, that what has started out as being an attempt to deepen the level of economic integration between Australia and New Zealand has ended out in legislation which has been poorly translated through the political process into a bill. And I would note that it was agreed by Cabinet in November 2011. We see the process as having been deeply flawed, particularly the single patent application process, SAP, the single patent examination process, SEP, which was subsequently withdrawn from this bill. We see the remaining elements as being, firstly, a retrospective amendment to Section 92, and we don't regard retrospective amendments as being good legal practice and good parliamentary practice, and we reluctantly agreed to this basic correction of an error in the previous legislation. The final element that is remaining is the Trans-Tasman joint registration regime. We have considerable misgivings about this part of the bill, but we rather reluctantly have decided to accept the suggestion from the committee and support the legislation. We echo the concern from previous speakers about the poor process used in this legislation. Submitters uniformly complained about not having been consulted. We regard that as being more than an oversight. It indicates as failing to properly undertake the work that is required on this bill. And we see that submitters uniformly opposed the proposals put forward. I think there's a wider implication here that other professions in New Zealand should be looking anxiously at this politically motivated process. And I think as parliamentarians, we need to remember that part of our role is to defend New Zealand's interests where there are costs that fall on New Zealand professions from harmonisation proposals. We consider that the remaining legislation would generate some potential benefits in terms of joint licensing, depending on how the legislation is implemented. And we support the submitters who emphasise that there could be flanking measures that help. So, for example, locally responsive governance, so that New Zealand patent attorneys are not disadvantaged by additional travel costs, a point raised by many submitters, and not disadvantaged by rules that are not appropriate to the New Zealand market. We also think there are other measures to support this legislation that should be put in place, such as the New Zealand trademark attorney regime. In parallel to the Australia trademark attorney regime, New Zealand doesn't have one at present, and it would go a long way to making sure that this legislation was not disadvantageous to New Zealand patent attorneys. And secondly, a New Zealand qualification scheme. There needs to be a New Zealand accredited course of study because there are differences between the New Zealand and Australian legislation and the market. The Green Party supports a sound system for patenting and innovation that is New Zealand relevant, not just borrowed, as we've seen in the relentless drive to import patent regimes from other countries. I've seen it most evident in trade agreements, such as the recently demised Trans-Pacific Partnership Agreement, where the patent provisions come primarily from the interests of the major patent-holding countries in the United States and in other cases from the European Union. And I think we need to be very careful that our innovation system isn't being loaded down by excessively strong patents and copyright. We note that in the TPPA negotiations, there was a reference from officials to overly burdensome regulation that would be introduced by the patents proposals under the TPPA. In summary, Mr. Speaker, we support this legislation. We call for the flanking measures, as I've outlined, to ensure that New Zealand patent attorneys and the sector more generally are not disadvantaged vis-à-vis Australia. We rather reluctantly support this bill, but would exercise a strong note of caution with regard to harmonisation proposals that affect other professions. Thank you.